Prashant Bhushan made two tweets. The first tweet was to the effect that he was showing the photo of CJI, Chief Justice of India, riding a very costly motorcycle valuing about 50 lakhs. And he commented that the CJI is without mask and helmet. The courts are in lockdown mode. The people are not getting justice and they have no access to the justice. The second tweet is to the effect that although there is no emergency in the country, but for the past 6 years, the Supreme Court has destroyed the democracy, and in particular the 4 Chief Justices are responsible, and this will go down in the history. One Maheshwari made a request letter to the Supreme Court to consider this as a contempt of court, to take action against them. The Supreme Court took note of it and issued notices to Prashant Bhushan and also to the Twitter management. Prashant Bhushan appeared before the court and he contended that he has no malefides in making the tweets. It was all bona fide, and that he has exercised only his freedom of speech. The court rejected his contention and held that the first tweet is only individualistic, therefore it does not amount to contempt. Insofar as second tweet is concerned, the court held that it amounts to contempt and adjourned the case to hear on the sentence. In the meantime, when the proceedings were going on, some high-profile individuals filed a writ petition challenging the validity of the offence of contempt of court as being derogatory and in violation of the freedom of speech. The Supreme Court, however, did not club both the cases to hear. They left out the validity of contempt of court to be decided separately and only considered the contempt petition against Prashant Bhushan. The Constitution, which gives the right of freedom of speech, also envisages the offence of contempt of court. We find about in 4 places in the Constitution there is a reference to this contempt of court. Firstly, Article 129 of the Constitution empowers the Supreme Court to take action against the persons who commit the offence of contempt of court. Secondly, Article 142 also gives right to Supreme Court to investigate, inquire into and to punish the persons who commit contempt of court, of Supreme Court. Court means Supreme Court. Besides, it also empowers Parliament to make law in this regard. The 7th schedule of the Constitution in the Union List at item 77, it also empowers Parliament to legislate a law regarding contempt of Supreme Court. Article 19 gives a right of freedom of speech, constitutional right of freedom of speech, but it is not an unqualified right, it is a qualified right. The same Article 19 provides the right to the state to impose reasonable restrictions on some subjects, some matters. Contempt of court is one of the subjects envisaged therein. The contempt of court, this issue, validity of contempt of court, is not for the first time it has arisen before the Supreme Court and is no more in res integra. On earlier occasions, in several cases, Supreme Court has dealt with this issue and has held that there is need for retaining this power of contempt of court to punish the offender who commits contempt of court. It was argued in the earlier also that it is archaic law, it is in conflict with the freedom of speech, therefore it has to be struck down. Supreme Court has rejected, but however said that this right has to be exercised sparingly, and then the court has to be very lenient in the matter of sentence. if the contaminer comes and apologizes, the court has to exonerate him, excuse him, and then without sentence he can be sent off. This is how the guidelines are laid down. The need for contempt of court is to have a deterrence, so that people should have discipline and respect for the courts. In our democratic system, we see that to hold trial for commit of offences and to punish is in the exclusive domain of the courts. If people denigrate the courts, disparagingly insult and make personal attacks on the court, attributing political motives and so on and so forth, in such cases court cannot shut his eyes and shut his ears. Court has to instill discipline, and that is the reason it is very necessary. Otherwise, if courts are do not have power to punish the contaminer who defies the very dignity of the court and rule of law, majesty of law, then people have no faith in the democracy and in the system itself. Therefore, it is essential that contempt of court as an offence has to be dealt with by the courts, so that to instill discipline and also to uphold the public confidence in the system, in the judicial system. Then coming to the next issue with regard to the sentence, I feel the court was very lenient. In the beginning, the court offered that if he apologizes, he would be let off without any sentence, something like that. He was very adamant. He wanted to become a martyr and wanted to show that it is an issue between court and Prashant Bhushan. Court found him guilty on the second count, on the second tweet. And the court, even while before imposing sentence, gave him an opportunity whether he would apologize. I think this was not necessary. Having found that he is guilty of contempt, court should have immediately punished him. The question of hearing a sentence was not necessary at all, because they say whatever the punishment now levied could have been levied on the same day itself. And cajoling him or asking him to apologize and all that was not, it's a very lenient view, I feel. And this procedure is not followed in every case like that. If it's uncommon, it's not followed. And if this case were to be precedent, I think it will be very dangerous. The deterrence of law get lost. The courts have to be firm in dealing with the cases of contempt and impose proportionate sentence firmly. And, nothing like cajoling anybody or asking him to whether he apologizes and all that, giving an opportunity. All that is not necessary. It should voluntarily come from the contaminer. He should himself change his mind, and then he should say, sorry, I did it in a bona fide manner, not knowing the consequence and all that. Otherwise, it will have a very dangerous effect on the system itself. People lose faith of confidence in the court if this type of misadventures of contempt of court offences are committed. Then people lose confidence, and the judiciary cannot also command respect. I think this should not be taken as a precedent, and I am sure that the courts henceforth will not consider this case as a precedent and deal with the contaminers firmly and impose proportionate sentence. I wish that the previous system the courts used to follow should be continued, and this case should be dealt as an unusual case because of the political overtones. There are certain sections who are bent upon denigrating the judiciary. We have seen in our experience that if you don't have good case on facts and law, then attack the court and attack the judge. And this type of strategies by the litigant should never be encouraged, and they have to be crushed in the bud. And I feel that the courts are capable of handling such situations in future deftly and firmly.